Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about a recent case from Ontario that established a new tort, the tort of family violence. The case is called Aluwalia and Aluwalia, and in that case, there were a number of disputes, including a novel claim by the mother of family violence in relation to the father's abuse during the marriage. In a groundbreaking decision, Justice Mantain awarded $150,000 to the wife in compensatory, aggregated, and punitive damages for the new tort of family violence. She found that the marriage was violent and that the damages suffered could not be compensated through by spousal support. But in light of trends, Justice Mantain found that it was important for our law to recognize the tort of family violence because abuse is a social issue that's already been criminalized and requires a corresponding civil remedy. Here today to talk about the case are three family law experts, Dawn Bennett, Andrew Feldstein, and Heather Douglas. Thank you all so much for joining us today. Dawn, I wanted to know if there's anything else you wanted to add to the background of the case.
No, I think the case was very typical, which is disappointing in terms of family law and domestic violence. Very often we do see cases where you have someone who is not the breadwinner within the home, who is abused, who doesn't report the abuse, who ends up separating or divorcing and is basically stuck. We see in this case as well that Miss Aluwalia, she ended up not being able to afford counsel. And it's very unusual to have a case that actually changes the law where the person's not represented by counsel. So on every level, she was truly a victim in this case who did very well. We're very grateful to see. She did very well in it.
Yeah, it was fascinating to me that she was a self-represented person in court and that led to the establishment of a new tort. Now, Heather, what can you tell me about the nature of this new tort? What needs to be shown or proved in order to establish the tort of family violence?
Thank you. There are three main elements. The first element is with respect to the conduct. The conduct needs to be a certain type of conduct, whether it be like violence or some sort of abuse. Then the second one is that it's causing harm and that it's a pattern of abuse along a long period of time. So there's certain elements that must be met. And those elements that come from the Divorce Act, Section 2, on how family violence is defined.
So, Heather, my understanding is that the test entails violence or a pattern of coercive control. So if there's one incidence of violence, would that be sufficient to prove the tort? You wouldn't need to establish a pattern of violence?
I think it's more important that there be a pattern over a long period of time, because if it's one incident, then you're not really meeting the test, which is dealing with a relationship between family members.
Okay, thanks for clarifying that. Andrew, what's unique about family violence as compared to other torts, which traditionally would have included some of those elements like assault, battery, or intentional infliction of emotional harm? Why don't those torts fully capture the experience of family violence?
Well, what the judge said is the other torts require one incident to take place. So you have to prove that one specific incident. So if you're going to prove the assault, you're proving that one incident of assault. Whereas the tort of family violence is about conduct over a number of years. But you also mentioned the tort of infliction of, all of a sudden I can't remember the name of it.
Emotional harm, yeah.
Emotional harm. That one, there's a case called Frame and Smith. It was actually mentioned in this decision. That's a Supreme Court of Canada decision that says that's not allowed between spouses because it will make the relationship in terms of their ability to co-parent and get along more difficult. And that was one of the arguments that was raised by the husband's lawyer in this case.
Oh, that's fascinating. So, you know, in the traditional sense, a tort would normally need to be brought in civil court. Dawn, how realistic is it for a spouse to bring a family law claim simultaneous to a civil law claim for assault, for example?
Well, I think, Christine, there are certain financial realities that we can't ignore. Litigation is expensive, and people don't plan to get divorced. They don't plan to be in domestic court. So it's always a cost that was not prepared for, and funds are always limited. No matter how well off the litigant is, it's a cost they never planned for. So to have a simultaneous claim, I believe, is very rare. It's very unlikely. I've been a lawyer for 24 years, and I've had exactly one case.
Welcome back to Canadian Justice, where we're discussing the new tort of family violence. Now, Andrew, the Divorce Act specifically prohibits the court from considering misconduct when making a spousal support award. What's the policy rationale for that? And what did the court find about the statutory bar in this case? How did she get around it and the judge end up getting this large tort award for the wife in this case?
Well, I believe the reason why the courts don't like to look at spousal misconduct is much like what Don was saying. Litigation's expensive. And when you start having litigation about spousal misconduct, it may take something that could be a 2-day trial and turn it into a 10-day trial of arguing about who's at fault. We as a public can't afford to pay for the administration of justice to do that. There's an access to justice issue. And B, people can't afford to pay lawyers with respect to that. In this particular case, though, what the judge is referring to is the fact that there is no way to compensate the victim of violence through spousal support because she can't look at misconduct. Now, that being said, it's a little contextual, and she didn't really open up the door with that, because if someone was assaulted throughout the marriage, and now they say, as this lady did, I suffer from anxiety, I suffer from depression, there's all sorts of fallout as a result of the damage that I've undergone at the hands of my former spouse, well, that goes to her ability to work. And when she says, I can't work, the payor spouse in that case is going to have to pay more spousal support if the court accepts her reason, which is in line with his misconduct. So the irony of it is, in one way, you're not supposed to talk misconduct, another way you do. But this really is, when I read this decision, which I think is very well written, it's talking about trying to compensate somebody who has been through really a horrible number of years at the hands of this perpetrator of violence.
Yeah, and there's certainly economic consequences to abuse. Now, Heather, family law, as Andrew said, it's a no-fault regime, with spousal support in particular being no fault. So, for example, if one spouse was unfaithful to another spouse, it isn't relevant to spousal support. But obviously, domestic abuse is different from infidelity. Maybe you could elaborate on how it's different and why the court should treat it so differently.
It is different than infidelity because there's an element of trauma that is very deep that comes when someone abuses their spouse or their children. And the court was trying to say that that trauma needs to be recognized and compensated for.
So, Dawn, one of the things that's interesting to me is that I want to know if this is a tort that would only really arise in the context of an ongoing family law claim. Would this only really be relevant if the abusive spouse actually has assets? Or could there be a case where, for example, a home insurance policy might be available to cover a tort, the way home insurance policies can apply to things like negligence, for example? How do these different systems interact?
Well, I think in theory, anything is possible. In reality, given the nature of insurance and that payouts are expenses, it's unlikely that they would want to add to the roster something else that would create a payout. I think it's just the practical reality of it. And I think that the difference with family. Could you repeat the first part of the question, please?
Oh, I wanted to know, would it only be relevant in cases where the abusive spouse had assets? So in this case, the order was for $150,000. Not every divorcing spouse has that money.
Okay. So in terms of assets, I think that it's realistic that the courts does not want to make orders in which the person they're just paper judgments. Mm-hmm. There has to be enforceable in some kind of way. And I think that in many ways, when you're doing litigation, you see that the spouse really does need to receive something, and maybe the law doesn't really apply for it in a direct way, and that having the assets makes it more likely, but I don't believe it would be a precondition of it.
I do want to get into what the factors are the relevant factors are in how the court will come to determine what the damages are. I imagine in this case, she's shown her inability to work, for example, because of the depression that arose out of the alleged abuse. But we have to go to commercial break. One of the other things I want to touch on is what exactly coercive control means, because a lot of these terms, assault, battery, even intentional infliction of emotional harm, financial abuse, these are all terms within statute, but coercive control doesn't appear there, yet it was one of the things that was argued in this case. We do have to go to commercial break, but I will be right back. Welcome back to Canadian Justice, where we're discussing the new tort of family violence. Heather, in the last segment, we were talking about whether one of these torts, which torts are often addressed through insurance policies. Would an insurance policy be available to cover a tort like family violence? What's your thoughts on that?
At this time, I don't think that the homeowner insurance policy would cover a tort of family violence. Those torts usually have an element of criminality to them, and most homeowner policies have exclusions for criminal acts. So you wouldn't be covered if you were committing actions that were intentional and they were of criminal nature. Most of the time, there are specific exclusions for that.
What if there's for example, a multi-generation family home where the homeowner has the policy, but another person in the home is the one engaging in the abuse? Then could there be a negligence claim then that it was the homeowner who was negligent for failing to intervene in some way related to the abuse, Heather?
There could be a negligence claim there. However, you would also have to look at whether that person would be considered an insured under the policy. Because if you're suing another person and that person's also an insured under the policy, again, there might be an exclusion for coverage.
Really fascinating insight there. Now, Andrew, this case, the award was for $150,000. What factors are relevant to the court when determining what the award for damages is going to be? How does the court determine what that amount will be once family violence has been found?
Well, when you read this case, you see that the first award of damages was $50,000 in compensatory damages. So the idea of that is to compensate her for her damage. She's going to need medical treatments. There's other issues that flow from that. And the judge commented it could have been higher than $50,000. Then she also found an additional $50,000 as aggravated damages due to the overall pattern of coercion and control that was exhibited by the father. And then lastly, she awarded another $50,000 in punitive damages because his behavior deserved that strong condemnation from the court. And each amount of that is what totaled $150,000. And it's interesting to note, you can see they're all round numbers. So if you're looking for something that would be a black letter adding up a bunch of numbers to get to 150,000, that wasn't there. I think at the end of the day, the judge is trying to do what she thought was right based on this particular case, and probably including some of the finances of this family.
Now, Dawn, in this case, there was a finding of what's called coercive control. And a lot of the other conduct in the marriage, assault, battery, those are all listed in statute and explained in statute. But coercive control isn't there. What is coercive control, and how do you make a finding of it? How would a court make a finding of that?
Well, coercive control is essentially, it's a calculated behavior. It's a calculated coercion. And it is mentioned in the Divorce Act in Section 2 under the Family Violence section. Now, you're looking for patterns of behavior, things that are designed to isolate the victim, things that's intimate partner violence. So it's basically acknowledging that there are certain behaviors that are conducted by parties that do cause different types of damages.
Heather, what would the benefit be of making this its own tort? Why not treat these as individual allegations of wrongdoing? What benefit is there in rolling everything into one new tort?
One of the benefits of rolling it into a new tort is recognizing that the behavior that's being performed is different than just an assault or a battery, that there's something unique when you have a family relationship and it's being abused, and that intimacy between people creates a very heightened level of trauma. And then the other benefit of having it in a specific tort is that it captures what's happening and it can be dealt with in the family law proceeding. And I note that Justice Mantain, before she was a judge, she worked at the Ontario Human Rights Commission. So I suppose that her background in human rights allowed her to say that the forum of the family proceeding was sufficient to deal with the tort family violence.
Dawn, we've got about 30 seconds. This judge certainly seemed to be very abuse informed. How common is that in family court settings?
I think it is very common in family court settings. However, I think that prior to the tort of family law violence, there are limits to what the bench could actually do. So people were well aware, but the acts, the statutes themselves limited what they could actually do in terms of recourse.
We've got to go. Sorry, Dawn, we've got to go to commercial break, but we'll continue this right after. Welcome back to Canadian Justice, where we're discussing a new tort of family violence recently established in Ontario. Now, Andrew, this case was from Ontario. Is it going to be appealed? Is it going to be a precedent outside of Ontario? Should we expect to hear other litigants plead this tort?
Well, it has been appealed, so it's going to the Court of Appeal of Ontario, which is in my view, one of the more well-respected Court of Appeals in Canada. I would imagine that in other jurisdictions, they're probably going to take a serious look at this case. And I would imagine lawyers there probably will try and argue it. And as it works its way up through the Court of Appeal, this could be one of the few family law cases that could end up in the Supreme Court of Canada as well. And if it makes it there, then we'll know right across the country whether or not it will be followed.
Now, Andrew mentioned that lawyers will make this case, but Dawn, in this case, or make the argument for the tort of family violence. But in this case, the wife was actually self-represented, Dawn. Can you talk about how common it is to be self-represented in family court? And if you think that created, a harder situation for the wife who was pleading something novel here?
It's extremely common for people to be self-represented. As I said before, litigation is expensive, and especially family law litigation, because it's not a planned experience. Now, I think in this case, Ms. Aluwalia did very well for a self-represented litigant. In most cases, the courts are understanding that everybody cannot afford a lawyer, but the litigants are still held to the same standard. You can't show up in court and say, well, I don't have a lawyer, so I'm just going to do whatever I want. So she has done quite well for herself, I think, in this case.
Now, Heather, in this case, the wife alleged violence that took place during the marriage, but had actually occurred years prior. And typically in litigation, there's a statute of limitation for certain claims. You can't bring a claim after a certain amount of time has passed. How does that apply here? And what should people know about limitation periods if they are dealing with abuse in a marriage?
Generally, the limitation period is 2 years from the date of the loss, or when you should have known that you had the claim. In this case, it sounds like she was always pleading the family violence in some form. She just made it official in 2021, and they got divorced and they separated in 2016. So it didn't sound like it was a new claim being made years after the pleading was issued. She was just formulating that explicitly.
And are claims of, for example, assault, are those subject to the same limitation period as other types of damages, or do they have a longer limitation period?
It depends on the type of damages that you are claiming for. Sexual assault, for example, may be one of those exceptions. So you have to look carefully at the Limitations Act and to see what applies in your specific case.
Yeah, and litigants should always be aware of limitation periods. Andrew, in this case, there were also criminal proceedings that had been commenced against the husband in this case. Do criminal charges have any relevance in a family law proceeding?
Well, they do, in the sense that if there's a conviction of an assault or repeated convictions, as a family law lawyer, it makes my job very easy. There's already been a finding of another court that this person has perpetrated these assaults. And when you're claiming damages for it, you don't have a very difficult case to argue. Whereas in this case, there was a question as to the credibility. Who was believed? She says she was assaulted. He says, I never did it. This judge had to make that determination. So without that conviction to follow, she had to make her case. That's a lot more work. That's a lot more time. That's a lot more energy. And if she had a lawyer, a lot more money.
But what can you say about the difference between the civil standard that would be argued in this case and the criminal standard?
Well, the criminal standard is beyond a reasonable doubt. And in this case, it's the balance of probabilities, which is 50.1%. So when you have a criminal case and there's a finding of not guilty in the criminal case, that simply means proof beyond a reasonable doubt was not established. And then when you're in a civil proceeding, it just means you didn't meet that burden of proof, but you still can meet the burden of proof of 50.1%.
Well, that's all the time that we have today. Don Bennett, Andrew Feldstein, Heather Douglas, I want to thank you all so much for coming on today to share your insights into this fascinating case. We've heard today about the new tort of family violence in Ontario and how the law has developed to recognize the unique harms of people, largely women, living with the consequences of physical abuse and coercive control. The spousal support system does not adequately address the serious harm caused by family violence. Will this new tort fill that gap? You be the judge. Now remember, a freer Canada starts with you.